Ladies and gentlemen, my name is Isaac Christopher Lubogo, and today I would like to have a very wonderful discussion on the law of forensics in Uganda. I want to begin by reminding those of you who may not know a little bit of what forensic will do for you. The use of forensic, for example, in the popular O.J. Simpson case was a significant factor in terms of, for example, DNA evidence. In particular, it actually played a very vital and crucial role. The blood evidence that was found at the crime of the scene and in Simpson's car matched to the victims, that was Nicole Brown Simpson and Ronald Goodman, was extremely compelling. However, the case was extremely complex, and the defense raised doubts about handling, for example, issues to do with contamination of evidence, and ultimately the effectiveness of forensic evidence was a point of contention. And the jury's decision to acquit O.J. Simpson was highlighted in the influence of many factors in terms of forensic evidence. And that's what gave us the, the morale or the impression to write the book called The Law of Forensics in Uganda, a proof beyond the shadow of doubt. And we made propositions in respect to if the gloves don't fit, then you must acquit. That statement was made by my friend Johnny Cochran, who is arguably one of the best legal minds in jurisprudence. So DNA contamination can actually be talked about, even though it is in small amounts, leading to incorrect or improper precautions, if not well taken, can actually misdirect or even cause you to lose a case, just like what happened in the O.J. Simpson case. DNA in terms of degradation, by the way, in terms of sample size, even in terms of the credibility of how it was collected, even aspects to do with human error, mistakes that were made during the collection. All those in terms of DNA analysis samples led to the fact that there were inaccurate results, and that's how they acquitted O.J. Simpson. You remember that called the trial of the century. So when you're interpreting, in terms of interpreting complex DNA profiles, they can be subjective in terms of different analysts or in terms of different conclusions when it comes to DNA evidence, as it were. But familiar DNA, in some cases, DNA evidence usually helps to point out, for example, to family members rather than specific individuals, that makes it necessary to conduct further investigations. We have this issue that is very popular in Uganda now in terms of DNA, especially when it comes to issues of what? Of childbirth, parentage, in terms of paternity tests. So that's a question now that demands forensics to interpret. So we as a country, we need to brace ourselves when it comes to the importance of the law of forensics. And that's why I'm making a case for this in terms of understanding. So that was by way of a foundation, so that I can give you a foundation of why it's important and some of the cases that have actually been played out over the period of times in terms of forensics and what forensics can actually do for you in terms of determination of criminal matters. So this argument that particularly caught my attention was that if the gloves don't fit, then you must acquit. This was basically a very key argument that was made by O.J. Simpson during the defense, during the trial, in terms of the murder trial, if you remember. And the defense argued that the gloves presented as evidence, which were alleged to have been worn by Simpson during the murder of Nicole Brown Simpson and Roland Goodman, did not fit him properly, and therefore, when he tried them in court, and that was something that caused a lot of drama, if you remember, during the times of the trial of the century. Those of you who probably are not well versed with that, there's a movie, by the way, of the run of his life for the trial of the century, the O.J. Simpson. So the impact of this argument, if the gloves don't fit, was attributed to a number of combinations in terms of factors. Things to do with dramatic moments, for example, the moment when O.J. Simpson literally tried on the gloves in front of the jury was highly dramatic and actually memorable. It garnered significant media attention and became the focal point of the trial. I remember one of the jury, when they were asked to say, why did you acquit? He said, listen, the gloves didn't fit. And the argument was OJ had, Johnny Cochran had actually said, if the gloves don't fit, then you must acquit. So there was an emotional appeal. The defense used the ill-fitting gloves to create a doubt in the minds of the jury about the Simpson's guilt. And they argued that if the gloves didn't fit, then he suggested that Simpson might have not been the perpetrator, in spite of the fact that DNA evidence had actually proved a number of components. So we're going to argue forensic law, we're going to argue reasonable doubt, but all those aspects in criminal law, the case must be proved beyond criminal liability, beyond the shadow of doubt, if you like. But reasonable doubt is in criminal law. The prosecution must prove the defendants gave beyond reasonable doubt. And the defense argument with the gloves played into the concept of reasonable doubt. So making the jury's question whether or not the evidence was actually strong enough to convict Mr. Simpson. Obviously, when you're arguing forensic, you should argue it in liaison or in tandem with other pieces of evidence, if you like, okay, other factors. So the gloves argument was just one of the elements in the defense case, but they also raised questions about handling of the evidence and the credibility of the investigation, the police investigation, further contributing to the jury's deliberation. Issues of race also had come into play. And so when we're making argument for forensic, we're not simply single-handedly it and saying that with the law of forensics, we're going to get it 100%, but it will help us to reach there. So, like I said, if the gloves don't fit, you must acquit. That argument had powerful impact. It was just one aspect of the trial, as I said, and the jury's acquittal of OJ was a result of a combination of factors that the argument presented by both the prosecution and the defense. And in criminal law, as I said, the prosecution must prove beyond reasonable doubt. If they don't do that, then the jury or whatever, they must acquit, because they'd rather let a guilty person go free than let an innocent one being incarcerated for that purpose. So during the O.J. Simpson murder trial, the defense team was led by obviously Johnny Cochran, as I told you, and Robert Shapiro. They played these significant roles in shaping the defense strategy and actually handling what they call evidential matters in the case. Now, in terms of remembrance, if you remember Johnny Cochran, why am I laying this program? Because the book that we wrote on forensic has a lot to do with that was our inspiration anyway. Johnny Cochran led the defense attorney and was perhaps the most famous in terms of that defense team. And he was very known for his charismatic and persuasive courtroom style, which I wish every lawyer would actually adapt in Uganda. I get so sick about the kind of jurisprudence we have in this country, where most of the defense lawyers in this country are men, other than standing like dead mummies and simply making a little bit of just gestures. They're really dull and boring. So I make a plea for us to open up our jurisprudence to a little bit more enigmatic, perhaps more charismatic, but also more direct and more innovative in terms of the law. Robert Shapiro was another guy who was one of the initial attorneys of O.J. Simpson. While he handled the lead team, obviously later Cochran took over, he played a significant role in crafting the defense overall strategy. Shapiro was actually involved in many negotiations. He was an expert, by the way, in ADR with prosecution, and was known for his legal strategy, which raised a number of questions about the integrity of the evidence in terms of the investigation. So the defense team also included other attorneys in terms of experts who focused on the reasonable doubt, as I said. And one that comes to mind is a guy that probably is important for us to discuss, especially because we're talking about the law of forensics. And I'll shortly mention something about him. But as I said, the questions in terms of collection and handling of evidence becomes a very important aspect, and these were raised in terms of creating a doubt, reasonable doubt, as I said. Under criminal law, the case must be proved beyond reasonable doubt. It's very, very important in terms of criminal cases. In terms of civil, it's a question of balance of probability. So O.J. Simpson's trial, highly important case when it comes to some of these issues, and there are many lessons that we got to know, and that's why we got the inspiration to write our book called Forensic Law Beyond the Shadow of Doubt. Yes, in addition, as I said, we have other lawyers who participated, especially the guy who led the DNA team. We'll shortly come to understand what that played, because that created, again, a foundation for the DNA team, because DNA would pin you or put you to the scene of the crime to a tune of almost 99.99%. The guy was called Barry Sheck. Barry Sheck was a renowned DNA expert. Incredibly, the other team, the defense team, also brought their guy, I think was an American Chinese, who was also an expert in DNA issue. But then these guys brought Barry Sheck, who was a renowned DNA expert and co-founder of the Innocence Project, who played the very, very important role in terms of the defense effort, in terms of challenging DNA evidence. And he raised questions about the accuracy and the reliability of DNA in terms of testing, how it was conducted during the case. Sharik's cross-examination, for example, of the prosecution witnesses regarding the DNA evidence was very, very instrumental in creating doubt for the forensic evidence presented by the prosecution. So Sharik's expertise in as far as DNA analysis and his ability to challenge the DNA evidence was extremely instrumental in the defense's strategy. In other words, he actually highlighted the potential issues with DNA, including concerns about sample, for example, issues to do with contamination, the validity of the testing procedures, and these obviously were actually pinching holes in the credibility of the prosecution. Some of you have watched this movie called How to Get Away with Murder, and this Keating makes very strong provocations in terms of how to do away with murder, and he raises issues like pinch as many holes as possible in the credibility of the evidence, give them another narrative, create another story, and these are things that as defense attorneys or defense lawyers or perhaps criminal lawyers should take bearing in terms of what understanding. So, as I said, Barry's Sheikh's expertise in DNA analysis was very crucial in raising the doubts about the prosecution case. So there have been quite a number of numerous serious forensic cases where, for example, forensic evidence has actually played a very significant role in solving crimes. I'll give some examples, some international and also some local, so that you can understand the importance of forensics and why forensics should be undertaken, perhaps in my opinion, as a very strong subject in the field of law in Uganda. I don't know whether there's a school right now, a school of law, which is actually teaching the law of forensics. The one that was teaching has probably phased it off, and now I'm told there's a university, the one by the government, I think, for the army, that does forensics. But number one international case is the O.J. Simpson case, which, as I said, it involved the murders of Nicole Brown Simpson and Rodman Goldman, and was one of the most famous examples of DNA evidence, although it was subject to debate as the issue was more racial than anything anyway. And there was the acquittal. It was based on the fact that there were quite a number of holes that were posed in this particular case. And I said, under criminal law, it's a question of proof beyond reasonable doubt. So that's something. And then we had another one called the Ted Bundy case. Now, Ted Bundy was a serial killer. Ted Bundy was actually captured and convicted. And in part, due to the dental records and the bite mark analysis. Think about a dental records and a bite mark analysis. These forensic methods helped to link him to several crime scenes and actually contributed to his conviction. I'll give you another example. We also have what they call the Boston Strangler case. This Boston Strangler case happened in the 1960s, where forensic evidence such as DNA analysis was not available, but fingerprint evidence was used to link Albert DeSalvo to the so-called Boston Strangler murderers, and this contributed to his arrest and eventual conviction. I'll give you another example. Another was called the Golden State Killer case. In this case, DNA evidence and the genealogy databases were actually used to identify and apprehend the Golden State Killer decades after his crime. Think about that. So a success of using DNA to solve this case highlighted the power of what they call the new forensic technique. So, I mean, I'm speaking extremely important aspects in the law of forensic for our country. And I'm going to mention a number of cases in our country that are unsolved, cold cases that are unsolved. There's another case that they call the Casey Anthony case, which talked about forensic evidence also, including traces of chloroform and the hair samples. Think about it. Traces of chloroform and hair samples that were presented in the trial of Casey Anthony, who was accused of killing her daughter. So Casey Anthony, ultimately, she was acquitted, demonstrating that even strong forensic evidence may not guarantee a conviction. But again, these are questions of debate that had to do with, again, the proof beyond reasonable doubt that is incumbent upon the prosecution. That's what O.J. Simpson asked and said, you guys, you represent murders. How do you go? He said, you see, mine is to present my best evidence, but the other people are to present the case beyond reasonable doubt. There was another called the Memphis 3 case. In this case, the convictions of 3 teenagers for the murder of 3 young boys who was overturned years later, imagine, due to the new DNA evidence. And the case underscores, obviously, the potential of forensic evidence on both convict and exonerate individuals. So we can argue that there were quite a number of successive forensic cases can vary due to the strength of the evidence, as I say. But the quality of investigation in terms of legal proceedings is extremely important. So forensic evidence can be a very powerful tool in terms of law enforcement. Its effectiveness also depends on the circumstances of each case and the ability for the justice system to properly evaluate and use that evidence. In Uganda, we can argue, for example, the Mumbere versus Uganda case. In terms of forensics, we have the Rarinda versus Uganda case. Then we have got Yoweri Nsenga versus Uganda case. Then you've got another one called Haji Abubakar Godi versus Uganda, and then the one of Henry Chifamonte versus Uganda, and then Dr. Agri Kienji versus Uganda. With quite a number of cases. So we have also got challenges in terms of unsolved matters, which remind us of the cases that we're doing. Unsolved matters. We're writing a book that had to do with unsolved matters. Talk about the Felix Kawesi matter. Talk about the Haji Chigundu, the soldier, of course, you remember. Talk about the Mayombo, the General Mayombo, then the General Ronda, then General Katumba, then Abiliga, and then Kagezi, all those issues. Many of those cases, we have not resolved them. What happens is that we simply go back and go to Scotland Yard, borrow, ask them to come and do things for us, and then at the end of the day, we have nothing. So studying law in terms of Uganda is extremely important, especially in terms of forensics. How does it help you? It's going to help you in some of these areas. Now I'm going to be a little bit more assertive and probably more specific in terms of how forensic law is going to help and why we need it to be adapted and co-opted in law school. Number one, crime investigation and justice. Forensic evidence plays a crucial role in terms of criminal investigations, in terms of court proceedings. Understanding forensic law ensures that legal professionals, including judges and prosecutors and defense attorneys or defense lawyers, can effectively evaluate and present evidence leading to what they call a fair and just outcome. Who would want their loved one to go guilty or unguilty without really substantive evidence? The argument is, as long as we can pin you to a criminal crime, then we can say hallelujah or hooray for that purpose. Improving the legal system. By studying forensic, legal practitioners in Uganda, for example, can actually contribute to improving what they call the country's legal system. They can actually advocate for the adoption of modern forensic techniques and standards that enhance what they call the reliability of evidence that is presented in court. So remember that. Another advantage why we need it in law schools is in terms of international comparisons. Now, while Uganda obviously may have its unique legal challenges, studying the law of forensics in institutions, for example, like if you make a comparative analysis like maybe Harvard or Yale, can provide valuable insights in terms of comparative perspectives. So these institutions often have what they call cutting-edge research and international best practices, and therefore that can be adapted by Uganda by way of benchmarking. And those are the things that I keep telling our students and our country in terms of why we need to go that way. Another advantage of studying forensic in law schools would be aspects to do with human rights and justice reform. When you understand the law of forensics as a crucial aspect in terms of human rights, then we will have advocates and policymakers. It will help us to identify areas where, for example, the justice system needs to reform to protect the rights of the accused and to ensure the integrity of evidence in terms of prevention of wrongful convictions. How many times do we see our loved ones being convicted wrongfully? There's nothing as bad as someone being convicted wrongfully. When you go to the likes of those remand homes or even prisons, you'll find there perhaps many people, unfortunately, who may not be there for the right cause. Interdisciplinary as a knowledge factor is also another aspect. Forensic law is inherently interdisciplinary in terms of involving elements of science, technology, and even legal practice. So this multidisciplinary approach can actually help Ugandans in terms of legal professions with what they call diverse skills and set them to increasingly valuable in terms of competing with today's complex legal landscape. So that is another aspect. Then there's this argument called the public trust, not more like public trust doctrine anyway, but the aspect is a well-functioning forensic legal system can actually enhance what they call public trust in the justice system. So when people believe that the evidence is handled professionally and impartially, they are more likely to have confidence in the legal system. We'll probably forget about things like mob justice. As my undergraduate, I did my thesis on mob justice and why, the tenability of it. And I could understand why people go for mob justice, because they have lost faith in what? In the system of the police, in the investigation and stuff like that. But if they know they have substantive, forensic, facets or whatever, then they can be able to trust our system and we shall have no challenges in terms of some of these challenges. So, in summary, when you're studying the law of forensics in Uganda, it can be very, very important for you. It's prestigious for an institution. As I said, I made comparison with other universities, like Harvard, for example, and Yale, which is essential in terms of improving our legal system. So by ensuring that these are evident, we shall support our justice system. We shall have substantive empirical data that can be able to highlight the importance of the discussion in terms of justice to be seen. It's not no more a question of simply talking about justice, but justice must be seen to be served So studying forensic law in Uganda, as I said, is extremely paramount due to quite a number of reasons. I will try and break down a few of those by way of conclusion so that you can understand, because I cannot explore. Our book on the law of forensics is probably this big. You can find it at lubogo.org or suigeneris.com on some of the major universities here, but also majorly many of the bookstores here. But it will ensure justice, as I said. Forensic law is the heart of ensuring justice. It provides as a tool in terms of techniques necessary to accurate, establish the guilt or even innocence in terms of criminal law. And by understanding and applying these principles, as I said, our professionals can actually be able to prevent wrongful conviction and ensure the guilty are held accountable. Not so. And then enhancing the argument called credibility, as I said. We cannot just go wrong when it comes to. Some of you have seen those justices or justice images or whatever, what other people call those crafts, where the woman is blinded and then is holding a sword and stepping on a stone. Blinding, the argument of fairness and just without being, without favorism, So we need to assure the citizen that the evidence is thoroughly examined, scientifically validated, and impartially presented in court, so that the trust is vital in terms of maintaining social order and faith in terms of the rule of law. And again, when it comes to crime prevention, is another aspect. In Europe, you don't see so many of the things because of the levels of proof. Here, we have to do it because forensic law not only addresses crimes after they occur, but also contributes in terms of crime prevention. Talk about the Big Brother now. If we know these cameras, you realize that there's a lapse in terms of knowing or in terms of the crime occurrence, because people are likely to be easily smoked out. So we have to understand that it will help us to protect and prevent wrongdoers in our society. In terms of human rights protection, understanding forensic law is essential. It will safeguard the human rights of both the victims and the suspects. It will ensure that the investigations are conducted fairly. It will respect the rights of all parties involved, and it will be particularly crucial in Uganda, where human rights issues have actually been of serious concern. Not so. So that becomes extremely important. Another important aspect has to do with effective resource allocation, as I said. So by studying forensic law, Uganda can actually allocate resources more effectively or efficiently in terms of prioritizing cases that are based on merit, reducing what they call backlog in terms of unresolved cases, and also expediting cases in terms of legal processes. And another aspect also in terms of modernizing and what they call technological advancement for that purpose. Forensic law is closely tied with technological advancement. So by embracing this field, we allow our country to modernize in terms of legal system and also incorporating what they call cut-edge forensic techniques and technologies. So this not only will improve the accuracy in terms of investigation, but also maintain a sync with what they call global legal standards. And that's the argument I was propounding with Professor Golling when I was in Germany. He was saying now time is coming with AI and with the number of technologies that there's almost no difference between the different jurisdictions, in spite of the fact that we're in Africa and they're in another part of the world. So in terms of international cooperation, understanding of forensic law also facilitates international cooperation on criminal cases and also extradition proceedings, for example. We will ensure that Uganda can actually effectively cooperate with other nations in cases that involving transnational crimes. Talk about Interpol and the likes. So those are important. In terms of career opportunities, man, that's another one. That's another one. That's a Pandora box opening. In terms of aspiring legal professionals, studying forensic law will open up a range of career opportunities. It will allow lawyers, for example, to specialize in areas. I just told you about Barry Sheikh, who was an expert in DNA. Okay, so it will allow you lawyers and other people to specialize in terms of high demand, both nationally and internationally, leading to the world of impactful career in terms of rewards. And also another important in terms of national security. Talk about national security. As Uganda, I know we're very deeply concerned about security, but forensic law will play a very, very crucial role in terms of national security by aiding into the investigation of, for example, terrorism and other threats. And also a strong forensic legal framework is extremely essential when it comes to protecting the nation from security risks. And then the aspect of restoring faith again in justice. I mentioned that in terms of mob justice, where people take the law into their hands. In recent years, Uganda has faced a lot of challenges that are related to public perception in terms of corruption and even biases within the legal system. So if we have a robust forensic legal system, it will help us to restore faith in justice by ensuring transparency and even accountability. So, my friends, listen, Listen, we have been able to dream a little bit ahead. We've been, like what Bernard Shaw said, most men see things as they are, and that's why we dream of things that are not, and that's why not. So by studying forensic law in Uganda is not just a matter of academic interest. It is a necessity for upholding justice, protecting human rights, maintaining social order, and by investing in this field, Uganda can address those legal challenges, foster public trust, and contribute to a safer and more just society. My friends, we have course descriptors that have developed in terms of the law of forensic. You can find them. We have a book, as I said, The Law of Forensic, Beyond the Shadow of Doubt by Isaac Christopher Lubogo. God bless you and thank you for your attention. See you next time.